The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Welcome. And I want to particularly welcome the students from Bergman Academy. Thank you for being here. There are 3 cases that will be submitted this morning. Those cases are as follows. Walnut Creek Townhome Association versus Depositors Insurance Company. Second case is the City of Des Moines versus Mark Ogden. And the final case is State of Iowa versus Kevon James Henderson. That last case is now submitted to the court without an oral argument, and we'll proceed to hear the arguments in Walnut Creek. Mr. Margolin.
May it please the court. Counsel. The issues that we believe are presented to the court today on behalf of depositors deal with what is the proper scope of an appraisal. Does it include damages and causation, or damages only? And depending on how the court comes down, either an appraisal should be consist only of damages and not causation, or it should include both. What is the reviewing standard that a reviewing court should apply when looking at an appraisal award? In preparing for today's oral argument, I was a little conflicted because on the one hand, we have the district court decision from Judge Hanson, who allowed the appraisal to proceed with the umpire able to address causation regarding the issue of damage to the roofs at Walnut Creek, subject to further review. And of course, Judge Hanson ended up finding that the appraisal award was not binding. On the other hand, in the dissent written by Judge McDonald of the Court of Appeals, he argues that North Glen, case that we'll be talking about, or I'll be talking about this morning, the first North Glen case, and the second one as well, should be reversed because causation is not a proper subject of appraisal. In other words, you can have, in these types of cases, an appraisal without addressing causation. Now, they both
as a practical matter, Counsel, doesn't that conclusion lead almost certainly to a determination that the appraisal process is limited only to an extremely narrow range of cases? For example, it strikes me that if we focus our attention on roof damage cases, just since that's what we're talking about here, you know, in a circumstance in which a hail event happens within, let's say, 30 days after the building is constructed, we wouldn't have much of a causation question.
Correct.
But in contrast, anytime you have a roof with some age on it, you know, you're going to have the complications of oftentimes multiple hail events over a decade, for example. You're going to have wear and tear over a decade, and there's always going to be, in the most common cases, this somewhat complex question of causal connection between a particular event and the damage claimed. So it strikes me that you know, if you take causation out of the analysis for the appraisers, you're going to limit their role to a very narrow, almost negligible number of cases where their determination will have any consequence whatsoever, under your view. Am I wrong?
Well, I would respectfully disagree. I would indicate in response that in the case of the roof that's been up on a building for years and there have been other hail events, it is totally proper and would be appropriate to allow the appraiser to go up and inspect the roof and look to see what the cost is going to be to replace the roof. And then the parties can litigate causation later.
Well, but there are a lot of roof damage cases where replacement isn't required, and it's just a matter of some repair. And so you still have that causation problem, don't you?
Well, I could see it might raise its head in that scenario, but I think overall, I think you can still allow the appraisal process to continue with just the appraiser looking to see what the cost of repair is, because that's what an appraisal is in terms of the general definition of an appraisal is trying to put a value on a property.
Well, but the first question is, what are we appraising? And then what's the value? It seems to me, and this is kind of similar to Justice Hecht's line of questioning, but so I'm hired as an appraiser, and let's say I understand my role is to come up with a value, but then I come to the premise and say, well, what am I valuing? Is it the replacement of the entire roof? Is it the replacement of metal accessories? What am I appraising? And isn't that the first question that gets asked? And if it is, then you're in causation land, I think.
You can break down what areas you want the appraiser to look at. What I'm suggesting is that, again, as Judge McDonald indicated in his dissent, that you can have an appraisal go forward without addressing, I know it's a fine line, but you can have it, just have the appraiser look for the damages, what's the cost of repair or replacement, without addressing causation.
But I think what Justice Appel and Justice Hecht is getting at is that if you have a large roof that had 2 or 3 or 4 prior hail events, is the appraiser supposed to appraise every 10 square feet or every square, which is 100 square feet, and get the cost of every square, and then someone's going to decide which squares are covered and which squares are not? It makes the appraisal worthless at that point, when the appraiser doesn't know what he or she is appraising.
I think, again, the way that issue can be confronted is have it bifurcated. I know what we're talking about in terms of, is the process really working if we're having the appraiser try to break down a number of different areas of damage and try to indicate what's the value for each of those areas without knowing what causation, maybe what the interplay is there with causation.
Why would you bifurcate the trial as either a claimant or an insurance company? Because you're obviously going to have someone up there who knows something about roofing and know the cost of repairs. So you have them go up there, and they first go up and they go up there and decide causation. And then after the judge decides the case, or the jury decides the case, you then have them go back up and do a cost that's binding on the court. I mean, it makes more sense for each side in one trial for judicial economy just to, get their experts up there, say this is what it is, and the cost. It seems to me, that your position could lead to less appraisals than more appraisals, and the whole purpose of the appraisal is to bypass the court system.
I think, Justice Wiggins, I think what we are trying to argue and formulate is we understand the appraisal process has merit. There are plenty of policies, obviously, that have the appraisal clause within them. But I kind of come back to what Judge McDonald wrote in his dissent in terms of being able to see the bright line between having the appraiser inspect and come up with a dollar figure for damages, and then have a full hearing in court as to causation, if there is an issue of causation.
So the
There are-
appraiser, the appraiser, I take it under your scheme of things, really ought to come up with alternative appraisals. I mean, on the one hand, if you do a total replacement, it's $1 million. On the other hand, if you are replacing only for this damage and that damage, it's $250,000, and the metal accessories is $150,000. Is that what you're, and that way, then, in subsequent causation, you could pick and choose. Is that the process you're looking for?
Well, if it's an injury to a single piece of property, such as a roof, caused by several events, let's say hail or a construction defect or
The
whatever.
appraiser's not supposed to figure that out according to your
Right,
view, I
right.
think.
And that's what I would submit, or on behalf of depositors, that's our argument, that's our position.
Should have multiple appraisal, I mean, the appraiser should package it in certain, in different ways and then allow the court later on to pick.
I'm sorry, you can have the appraiser come up with the dollar figure as to what it is to replace the roof, if we're talking about a roof. And again, at the court, that can be broken down in terms of what causative element resulted in that particular,
Here's the dilemma I have, Mr. Margolin, and I think you may be getting some of this from different ones of us on the bench. I mean, it does seem to me, in order to determine damages, you necessarily have to determine damages caused by what? There has to be some baseline that you're looking at. On the other hand, I understand, I think the other side has a problem as well, because the appraiser can't determine coverage. Coverage, you also need to determine causation. So where does that leave us? What are we supposed to do?
well, and that is why I would respectfully submit that the roadmap that Judge McDonald has laid out in his dissent, we would ask be adopted by the court. Because what it allows is that break. You have the appraisal go forward and look and put a dollar amount on the property loss. And then you can litigate fully in terms of depositions, discovery, and so forth, and have that causation issue addressed. It can be done.
Would that undermine the purpose of the appraisal is to have this efficient, inexpensive, relatively quick method to determine the amount of the loss? If you have to litigate causation after that process through a district court trial?
I don't think so, just because you're going to litigate causation, but the dollar figure is set. You're not going to relitigate that. So you're limiting the trial to just the causation elements. And I understand, while it would seem to work more efficiently, possibly, to have everything done, to have the appraiser up on the roof and address causation as well as damages, but it seems as though to do that, and with the standard that is in play now, with what the Court of Appeals has said in North Glen, that you were supposed to look for a mistake, fraud, or malfeasance, is clearly inadequate. If you are going to say that the appraiser should go up on the roof and address damages and causation, and then the only way that that award can possibly be not considered binding or conclusive is to have depositors, in this case, try to come up with some evidence of fraud or mistake or malfeasance, is clearly inadequate and not the direction that we should be going in.
Well, of course, if you, go ahead.
Well, it seems to me, too, that we're dealing with a very, very unique situation here, because most times when you're talking about an appraisal provision like this, you're going to be dealing like with a single incident. And roofs are very, very unique because, as we've seen in this case and other cases, you can have multiple, deterioration of something that may result in a loss. You can have catastrophic events such as a hailstorm. And so the appraisal itself and just the language itself talks about the amount of the loss, and so I think we're not throwing out the whole idea of appraisals, because I think they have a valuable place, but most of the time, if we're talking about the value of a building caused by fire damage, it's a lot simpler than the case that we're dealing with here, and that's where I think it just complicates it when you try to have other experts offer opinions on causation.
Well, I think in terms of bringing experts in, I think they need to be brought in, again, to address causation, and the appropriate place to bring them in would be at a trial once the appraiser has determined damages. The fraud and mistake and malfeasance elements that North Glen talks about, they were discussed originally in cases where the only issue was damages and not causation. And I think that's a key distinction. And when North Glen 2 brings into the fold fraud, mistake, and malfeasance in a case where clearly there was a causation argument, and that's the standard, that closes the courthouse doors to a remedy that has not yet fully been litigated. I see my time is up. Thank you.
Thank you as well, Counsel. Mr. Johnson.
Good morning, Your Honors. May it please the court, counsel, students. I'm extremely grateful to be here today before the Iowa Supreme Court. I'd like to start, actually, the court raised a lot of arguments that I wanted to raise. So I want to talk about some of the issues that were just being discussed. First
Let
and
me
foremost,
raise an issue that we didn't raise earlier. Sure. When I read the appraisal language in the policy, it seems to me that the policy language cuts against your argument, because the last sentence of the appraisal language says, if there is an appraisal, we still retain our right to deny the claim. Now, if the appraisal determines causation and the appraisal determines value, under what basis can they deny the claim?
that is the perfect question to be answered actually by the underlying case here. The appraisal panel determines all issues incidental, all fact questions. For all intents and purposes, they're a jury. The court's role is to determine whether there's liability for their findings. So, like in this case, the appraisal panel came up with an award of 4 separate things. They were asked, how much hail damage is from this 2012 storm? They went out and made a determination. X amount to roof, X amount to siding, X amount to soft metals, and X amount to air conditioning units. All of the first 3 things that I mentioned, roof siding and soft metals, those are all covered under the policy. So the court correctly found that those items are covered. But guess what isn't? The air conditioning units. So there is this critical distinction between what's covered under the policy and what's caused.
But counsel, doesn't this policy also have an anti-concurrent loss provision or exclusion that, for example, if the roof damage is caused by defective shingles and there's this pending warranty claim, that under the policy, if that's enforceable, no coverage for, even though there's also those same shingles were damaged by hail. Who decides, who separates out the warranty, the pre-existing defective shingle amount of the cost of a new roof from the hail damage part?
Sure. The answer to that is that the court will determine these liability questions. Who's liable? Who's entitled to an offset? Does the policy cover this concurrent loss? Is that a problem? But what the appraisal panel would do in that situation is the appraisal panel has to determine when they're looking at a shingle, this shingle would be a perfect example. Is this a hail ding or is this a material defect? The panel didn't award any dollars to the material defect. Reason being, most likely, is they're a group of experienced construction experts on the roof. They know whether or not something is hail damaged or whether something is damaged because that shingle is particularly susceptible. In addition, in this case,
Counsel, just on that particular point, you were addressing the fact that the appraisal panel didn't award any amount for for factors, causal factors, other than the hailstorm of August 8, 2012. And that's what their appraisal award document says. But I'd like to direct your attention to the last sentence of that same paragraph. It says, and I quote, "The award does not include an evaluation or determination of coverage, policy exclusions, or the relative causation of the same." What does that refer to?
Yeah, I don't know. That's confusing language. Here's what I can tell you, and I don't know. I don't have a great legal answer. They're using a form, and that's what that form says. So if I take a step back and I look at the document and I ask myself, what does this say? It says, an award of damage from a hailstorm from 2012, and here is an itemization of damages. I'm not sure if that language means they didn't determine the causation of coverage issues. They didn't determine what caused the loss. But here's what I can tell you. The plain face of that document says that they determined that there was X amount of damages from that year. Do I wish the award was more artful? Yeah, as an attorney, I wish it was. But to answer your question, honestly, I'm pretty sure it was just a form somebody probably found.
I guess I don't have the same trouble reading that you do. It says relative causation of the same. I think same means the loss. They're not determining relative causation because, as Justice Waterman indicated, that's a coverage issue. There's an anti-concurrent cause provision.
Sure.
So why can't a court come in and allow depositors to say, well, all right, here's the baseline. This is what we're dealing with, but we can establish that some of this is excluded because of the anti-concurrent clause provisions.
Yeah, that's so easy to give the panel that question. Tell me how much of this loss is attributable to this damage. It's so easy. And I know you don't want to hear what happens in Minnesota, but that kind of stuff happens in Minnesota all the time. Panels are asked to determine separate causes of losses. They put a line item on the award, and that's it. It's very simple. And the question is, for this court, is what makes the most sense for Iowa policyholders?
No, not quite, because it seems to me, if the policy excludes concurrent cause, which is, by the way, not an unusual policy, I mean, I don't know if it's saying too much state standard, but it appears frequently. Seems to me this appraisal form just followed, the last few words in the appraisal. I just followed kind of standard policy language that concurrent causes are determined by a court.
Yeah, and I think that the difference is the panel can determine what caused the loss and how much, right? But that's where their job ends. The court's role is to determine whether that, like in this case, that anti-concurrent causation exclusion is enforceable and what it means. So if there is an amount of loss attributable to an excluded cause, that goes on the award form. The appraisal panel doesn't determine whether anybody is liable for it. The court does. The court determines whether that anti-concurrent causation provision excludes coverage or whether there's liability for it. And to some extent, that happened in this very case, not for the...
But a lot of coverage issues are determined by causation. I mean, the best example is flood. You know, if it's flood, it's not covered. But if the water damage is caused by a roof being blown off and water coming in, it is covered. So causation becomes a critical part in any policy as to whether or not there's coverage. And the exclusions all go to different types of causation for things. So I don't know how you separate it out, and again, the language of the policy says they could still deny it, even though the appraisal says it. The appraisers say this is what the cost is.
Yeah, and I think that goes back to this critical distinction between the two. Is there's a difference between coverage and causation. Are they intertwined all of the time? Yes, but they're never inextricably intertwined. They're only intertwined in as much as the causation question very often answers coverage under the policy, but it doesn't always. And the appraisal panel is never making that determination. So, for instance, in our air conditioner example here today, the appraisers found that there was X amount of damage from that hailstorm. The court's role was to determine that the policy doesn't provide coverage for it. Appraisal panel did causation, court does coverage. Now, if the court looks to the Quaid case, which is what North Glen really relied on, you'll find that all of these issues were actually present in that case. The insurance company looked to deny the claim based upon anti-causation for wind damage. They said that it was from wear and tear. not from wind damage. And the appraisal panel agreed. They said there is $0 from wind damage. And they didn't have to come up with a number for the deterioration because there was $0 of covered loss. And the insurance company in that case actually moved the court to establish this very rule that this court is considering today. In fact, if you look at the history of where this is developed in other jurisdictions, it is almost exclusively the insurance company that's pushing for this. And I think the reasons are pretty simple, is this process, it's not without its flaws, it's not perfect, but it is quick and it is inexpensive, and there's checks. To think that mistake, fraud, or malfeasance isn't a sufficient basis to overturn an appraisal award, it's not that much different than an arbitration award. It's
Counsel, you know, as I understand Mr. Margolin's argument, he doesn't like North Glen, and I think would have us disavow that analysis because it allows causation to be considered by the appraisers. But in this case, Judge McDonald, I think, was of the view on his dissent that, and actually Judge Hanson was as well, that if you apply the North Glen factors, you still lose. So I'd like you to spend a few minutes explaining to us why the North Glen factors, the nature of the damage, the possible causes, the parties, the dispute between the parties, and the structure of the appraisal award, why those factors should lead us to affirm the Court of Appeals decision.
Sure. The North Glen standard is simply that the appraisal panel can determine causation, and absent some finding or some extraordinary circumstance of fraud or mistake, that the appraisal award is binding on the parties, not as to coverage, just as to the amount and cause of loss. So in the underlying action, the appraisal panel, actually, they heard evidence from the same experts that the court heard from. Only difference being is the panel was made of construction experts. They were on the roof physically inspecting the damage. There is arguably no better panel of people. And by the way, the appraisal clause requires that they be competent. These are always going to be construction or insurance experts. In this case, it was an insurance adjuster, and a restoration expert that's been like 40 years in the insurance industry doing appraisals and estimates for them. So those three people heard from two contractors, they heard from two public adjusters, and those people presented evidence of this is hail damage and this isn't hail damage. The appraisal panel, using their collective experience, said, okay, here's how much we think is hail damage. They didn't attribute anything to deteriorating shingles.
But if there's, even if we disagree and the experts were better, it's a substantial evidence. And, tell me why there's not substantial evidence to support the district court's finding that it wasn't hail damage.
Well, I'll tell you this is...
Substantial evidence does not mean more than 50%. It means more than a scintilla. It's a pretty low standard.
Well, I think actually, I'm going to answer your question, but I think this actually highlights the fundamental flaw in the proposed rule set forth by depositors. In that rule, as you noted, virtually nothing is appraisable. Nobody will do appraisals because if they do, all of the work that they did showing all of the damage to the appraisal panel is obliterated because it's redone before the court. Now, was there a factual basis for the court to make its conclusion? In all honesty, no, and here's why. The exclusion relied on by the court was anti-concurrent causation based upon deteriorated shingles. Guess what? One, that exclusion doesn't apply, as the court noted, and Judge McDonald didn't disagree with that. The second reason is that the only reason anybody was saying that there was no damage on the roofs was based on an engineer's opinion that cosmetic damage, meaning things that you can just see on the surface, didn't constitute damage. That was the only person who said that. In fact, Depositors' own contractor, provided testimony at the trial and before the appraisal panel that there was 6,000 to 9,000 hits of hail on the roofs. So was there substantial evidence to support his finding? No, he got it wrong, but that doesn't mean he's a bad judge. Good judges get it wrong from time to time. The problem is he doesn't have all of the benefits of being on site at the property. Take this out of a judge's hands. What do we do when we put this in front of a jury? Are we going to teach a jury in 2 days of trial how to establish hail damage when these appraisers have been out there doing it for 40 years and they still disagree? Absolutely not. This process works better. It's better for policyholders. It's better for the court. It's better for everybody when that question is in the hands of the appraiser. Can it get complicated? Sure. But there is no person or there is no party of people that are better suited to answer those complicated questions. That's their job. Why would we have a judge and jury do that when we have a specific process that's intended to keep things out of court so that question gets answered in a way that is not unassailable? If there's mistake or fraud, it can be overturned. If there's anti-concurrent causation questions, the court can step in and make policy coverage determinations.
Give us on that point, give us your quick summary of why the anti-concurrent clause provisions in this policy don't apply.
The quickest summary, and I'm not even sure if that issue is before this court, but I'm going to answer, is one, hail is an exception to the exclusions. So because there is hail damage, those exclusions don't apply. And two, the idea that the deteriorated shingles caused hail loss isn't actually supported by any fact on record. So it didn't contribute to the cause of the loss, and therefore it wouldn't apply anyway. There's literally, if you went through the entire record, not a single shred of evidence of anybody saying that that caused the hail loss or contributed to it. So for either of those reasons, those anti-concurrent causation exclusions don't apply. And the appraisal panel found that same thing. So in summary here, I'm running short on time. The court got this right in North Glen. They got it right in Walnut Creek, and they got it right in North Glen too. This is not a new rule of law in Iowa. It's always been the rule, in fact, since 1897. Appraisal panels are just like juries. We give them fact questions. Do we give them hard fact questions sometimes? Yes, we do. But liability determinations, those are reserved for the court. If this appraisal process is to have any meaning in Iowa, that rule has to stand, or every policyholder is going to be before the court. Again, that's worse for the court, it's worse for policyholders, and it's worse for insurance companies. Thank you.
Mr. Johnson, thank you as well. Rebuttal?
Thank you. Counsel just made the comment that liability determinations are for the court, and that is correct. You're gutting the coverage defense that a carrier might have if the appraiser is going to be able to speak to causation, and especially if it's going to be binding. In this case, they want the appraiser's determination that the August 8, 2012 storm was the sole cause of hail damage to the roof at Walnut Creek. They want that connection to be made. Therefore, Depositors doesn't have a coverage defense.
Well, this, you know, if we adopt your rule, this is going to work both ways, where you ask for an appraiser goes up there and says nothing's covered because of causation, and the judge can just throw that out and listen to the expert from the other side and hold you liable. I mean, is that, you know, it just takes the whole appraisal clause out of the picture.
Well, I think if the appraiser, if we have a system, Justice Wiggins, where we have the appraiser just up on the roof and just evaluating for cost of repair, just give us an estimate as to the value for the repair, just a number. And I know it kind of sounds maybe counterintuitive because the appraisal process we know is something that we encourage and we want to see done. But I think to be able to allow the parties to fully litigate the issues that they each have a serious right to in terms of due process, I think it can be done along the lines that Judge McDonald lays out.
I mean, what would your argument be if this appraisal came back and said none of the damage is related to the hail damage, but the court found all of it was and said you owe it?
Well, if the appraiser, it all depends, I suppose, are we allowing the appraiser to address causation? In your example, I suppose we are, right? Is that? So if that's the case, then we can apply the standards. If the court adopts North Glen, there are standards that were laid out in North Glen that they accepted or adopted from the Quaid Court. And they weren't mistake, fraud, or malfeasance. There were 4 factors that Judge Hanson, when he wrote his decision, felt he was following North Glen. And those 4 factors had to do with the nature of the damage, possible causes, the structure of the appraisal award, and the parties' disputes. And he went through in his decision and addressed each and every one of those factors in finding why depositors prevailed.
It seems to me the insurance industry wanted this clause in the policy for some reason, because it's a standard clause in most property policies. And to say, well, it's a great thing when the appraiser's for the insurance company, but it's a bad thing when the appraiser's against the insurance company, doesn't seem, correct to me. You'll apply North Glen on the other side when you win, but we won't apply it when you lose?
Well, but the standards that North Glen laid out weren't, well, the first North Glen at least, weren't fraud, mistake, and malfeasance. They were the 4 factors that, again, Judge Hanson thought those were the guideposts that he was supposed to rely on in terms of writing his decision and determining whether or not Walnut Creek prevailed.
Could I ask you about a point that Mr. Johnson made in his argument? He indicated that there is a legal reason why this anti-concurrent causation thing is not an issue anyway, because he said hail is an exception to the exclusions. Do you agree? And if not, why not?
Well, hail is an exception to the exclusion, but what's important to note here is, first of all, those clauses don't apply because Judge Hanson found that there was no hail damage at all to the roofs at Walnut Creek from the storm event of August 8, 2012. And secondly, their own expert, Walnut Creek's own expert, did not address wear and tear or any damage. Remember, this is the case where the shingles were defective before the storm, and they were already looking at removing those shingles before the storm event. So in this case, you don't have that triggering wear and tear or a defect that possibly causes this anti-concurrent cause clause to be in play, because they weren't looking at that. That's what the evidence was at trial. They only looked at the non-worn and torn portions of the shingles. That was their own expert's testimony. And so it never triggered, well, I see my time is up, so I must finish now. And we would ask that the court affirm or adopt Judge McDonald's dissent. Thank you.
Thank you as well, Counsel, and Mr. Johnson, thank you. The case is now submitted, and we'll next hear the arguments in City of Des Moines versus Ogden.